Hi! In this third and final clip for this session, I would like to talk about the international law of responsibility insofar as it relates to non-state actors, starting with the notion of indirect responsibility, which actually still implicates states, and then moving on to, on the one hand, the responsibility of international organizations, and on the other hand, the responsibility of individuals under international law. The first point, indirect responsibility, still refers to and implicates the responsibility of states. Already in the first clip, I mentioned that under the RCEVA, states are not actually able to outsource their international legal responsibilities to private actors. If these exercise governmental authority, so if these powers have been officially delegated to them by the states, the latter state still incurs international responsibility if there is a breach of international law. Now, even if the exercise of control of the state is more indirect and informal, so even if there has not been actually an official granting of governmental authority, states still might actually be held responsible for the acts of associated non-state actors. This is laid down specifically in Article 8 of the RCEVA, which it is worth reading out because it states that the conduct of a person or group of persons shall be considered an act of a state under international law if the person or group of persons is in fact acting under the instructions of or under the direction or control of that state in carrying out the conduct. The textbook offers two examples here and both are actually worth considering. The first one is the famous Tehran hostages case. In 1979, a group of militant students entered the US embassy during the Islamic Revolution of Iran. And in doing so, they breached the inviolability of the embassy that we talked about a few weeks ago. Now, two aspects arise here regarding the law of state responsibility. The first one is arguably more straightforward, namely that in letting the students storm the embassy and take the hostages in the embassy, the Iranian government in fact had breached its positive obligation to protect the US embassy premises as it is laid down in the Vienna Convention on Diplomatic Relations. So here it is the omission of action by the Iranian government that gave rise to international legal responsibility vis-à-vis the United States. The second aspect is somewhat more complicated, and it relates to the fact that Ayatollah Khomeini, the revolutionary leader and then head of state of Iran, welcomed and applauded the students' storming of the embassy and the taking of the hostages. And in doing so, he actually adopted the behavior of these private actors as the behavior of his state, Iran. Such indirect responsibility is recognized in the RCEVA and specifically in Article 11, which states that such conduct shall be considered an act of that state under international law if and to the extent that the state acknowledges and adopts the conduct in question as its own. The second example given in the textbook is likewise famous, and we already addressed it a number of times in this course as well. It's the Nicaragua case before the ICJ. In this instance, it was actually the United States which incurred the international legal responsibility, specifically for equipping, funding, and supporting the Contras, which were a paramilitary rebel group that tried to undermine and unsettle the established government in the state of Nicaragua. And in doing so, the United States provided a very clear example of the kind of international responsibility that is envisioned under Article 8 of the RCEVA when talk is of the direction and control of an actor. In this particular case, the International Court of Justice held that the United States had exercised what it called effective control over this paramilitary group, and therefore it had actually been in breach of various international legal obligations, including non-interference with the internal affairs of Nicaragua and, of course, importantly, the prohibition of the use of military force under international law. The effective control test developed by the International Court of Justice remains the standard applicable in such indirect responsibility scenarios, even though at a later stage the International Criminal Tribunal for the former Yugoslavia, in the Tadic case, developed and formulated a less strict approach, namely the so-called overall control test. The ICJ at a later stage responded to the ICTY's test by saying that this overall control test might be applicable when it comes to international criminal law, so insofar as individual responsibility is concerned. But of course, when it comes to state responsibility, it is the effective control test as envisioned in Nicaragua that needs to be accounted for. Moving on to the responsibility of international organizations under international law, the situation that we are confronted with is less clear, more problematic, but arguably also more fascinating. Now, it is fair to say from the outset that the norms that are applicable are in fact much the same as what we have seen under state responsibility, in the sense that international organizations incur responsibility when in fact there has been a breach of international law and when the action is attributable to the international organization in question. However, as Klabbers nicely explains, we soon run into a number of very serious practical problems. For example, which are the substantive rules that are applicable to international organizations? After all, it is states that give them their powers, and usually, at least, international organizations do not ratify or accede to treaties. So what are then these rules also under customary law that international organizations have to respect? Secondly, given that authority is delegated by states to IOs, how do we divide up the legal responsibilities between, on the one hand, the international organization in question, and on the other hand, the state parties, member states that are, so to say, behind this IO? And here we have a number of controversial, very interesting landmark cases that, however, do not provide very clear-cut general answers to this tricky question. To give one example only mentioned in passing in the textbook, the European Court of Human Rights was confronted with such a question in the case of Behrami and Saramati. Here the applicants had argued that France, Germany and Norway were in fact responsible for the actions of soldiers of peacekeeping operations that were conducted by the United Nations and NATO, specifically under its UNMIC and KFOR missions. But the European Court of Human Rights found that this was not the case, that in fact the member states could not be held responsible for these actions, and that likewise also the ECHR lacked jurisdiction over the UN and NATO, meaning that the applicants in fact were left without any remedy for the killings that had happened in this particular case. The case illustrates very neatly one of the main problems with the responsibility of international organizations. If responsibility is shared, if everyone is responsible, in fact in practice often it ends up that nobody is held responsible and that responsibility leaks out. And it is because of such disappointed hopes that scholars, but also some efforts by international organizations have been made to introduce administrative principles and reinforce the accountability, as opposed to the legal responsibility, of international organizations, so to say, as a short-term and more political remedy to the problem of the lack of responsibility. And finally, questions arise regarding the responsibility of individuals, of individual persons under international law. And I will keep this discussion rather short because in a few weeks down the road, we will do a deep dive into the area of international criminal law, where questions regarding how we prove that an individual has in fact committed a crime, what kind of evidence is required, what kind of procedures need to be followed, is part and parcel of the very area. Two remarks are already in order here, however. The first one being that the category of international crimes is a rather narrow one, including on the one hand what we call the core crimes under international law, so genocide, war crimes, crimes against humanity, and the crime of aggression, and on the other hand piracy and slavery. Acts other than these crimes would not fall within international criminal law. My second remark relates to the notion of intent and therefore brings us back to one of the reading questions for the day. And of course, when it comes to individual responsibility, when it comes to international criminal law, we cannot dispense of the idea of the mens rea, of the criminal intent, which is actually a requirement for a person to be found guilty of a crime. So while state responsibility in particular does not rely on intent, when it comes to individual responsibility in international law, this notion of intent becomes relevant once again. This concludes the videos for this week. I look forward to discussing all of the various aspects of responsibility, from state responsibility to individual responsibility, with you in class.